Vanakkam, good morning. Professor Dr. T.R. Parvendran, founder of this great institute, Dr. P. Satyanarayana, Pro Vice Chancellor, Dr. Abhishek Manu Singhvi, I need not introduce all of you. He is a great scholar, parliamentarian, jurist and senior advocate, and several times member of the parliament. Professor, Vice Chancellor of Medical Institute, Nitish Naikar, Professor CFML Vinay Kumar, Registrar Dr. Ponuswamy, Srimati Sudha, Dean of the Legal Faculty, Mr. Pradeep Rai, Senior Advocate from Supreme Court, other advocates, students, teaching staff, and my dear law students. Institutes such as SRM have brought a world-class education closer to home. They have ensured that talented young people do not have to migrate far. By imparting value-based education, discipline, they have contributed to regional growth, leadership, and strengthened the economies. Today, the Chancellor has inaugurated, on behalf of the Law Minister, the new building, and I am very happy that he inaugurated and created good infrastructure. May this new facility continue to shape future generations who will uphold the rule of law and strengthen the democracy. I am also happy inaugurating the statue of Father of the Nation, Mahatma Gandhi. At the outset, I need to state that 15 minutes time is allocated to me. And I will assure you, within the time limit, I will complete my speech. On lighter way, we have Dr. Singhvi here, and I don't want to take too much of his valuable time. He's a very senior lawyer. Most of you gathered here are law students. I congratulate all of you for choosing law. I wish that all of you join the practice. Although it is one of the most challenging professions, yet it is very exciting. There are already many esteemed guests lined up today to enlighten you about law. However, I will speak about the practice of law. The practice of law is not like any other job or profession. For instance, when a patient goes to the doctor gives him a medicine or prescription, something, and perhaps that is the end of his job. If you approach an engineer with a problem, he will give some design or solution. But however this legal profession is concerned, legal remedy is not in the hands of a lawyer. Because if you go with a problem to the lawyer, even he has wonderful ideas or knowledge to deal with the problem, ultimately one has to go through a system of procedure and institutions. To capture the essence of the legal practice, let me tell you a story which was written by a famous criminal lawyer in Telugu, Rachakonda Viswanatha, in the year of 1960. But every bit of it is still relevant. Of course, it is in Telugu language, but I have translated, and I am going to read the translation. Murthy, after getting a law degree, wants to start his career. He approached a senior lawyer with humility. The senior lawyer told Murthy to remember one important thing. He stressed that to succeed in this world, you have to do the following things. The early bird catches the worm, said the Englishman. Englishmen are very wise. He never does anything unless there is something in it for him. That is why he should reach the court every day early and get the gates open. And in the evening, wait until the court gates are closed. Always be alert and make sure that you are present in the court each and every day. Just like the cranes stand on the shores and foxes hang around the grayards. Of course, this kind of comparison is not very pleasant, but this is what we must do. If you want to shine, you must always be in the court. You know that the court is like a dense forest. Hyenas mimic human laughter in the forest. If you go closer thinking there is another human, the hyena will eat you. We lawyers need to attract the clients that come to the court in this manner. Don't be shocked. It is the fault of the person who enters the forest, not ours. But there are bigger animals than hyenas. If we are not careful, then those animals will eat us. These courts, law books were invented by the British. There are many courts to approach. There are many judgments of judges to pick and announce whatever ruling he wants. There are many rascals available to testify. We are there to justify. Whether it is a civil case or a criminal case, it is all about evidence, not about any truth. It is enough to just shout words like justice, truth, righteousness. Know that everything is illusion, maya. How can any sin touch us when the system is like that? All these sins go to the judges. All the expenses are borne by the parties and all the fees are ours. English people owe their existence to the courts. They are big trickers. They came to our country and sold our salt to us and said, you ate our salt and be loyal to us. They built courts and jails for us and built bungalows for themselves. After hearing this, Murthy became nervous and senior told him, don't be nervous. I spoke cynically, but this is the truth. If you remove the shred, the reality is this. Don't panic or be afraid of. This is how this famous Telugu writer and senior criminal lawyer who dedicated his life to serve the poor people in a humorous way explained the legal profession. Now, come back to our profession. A lawyer does not operate within insulated walls. His craft depends on controlling so many factors around him. A young lawyer walks on a tightrope every day. He is to understand the judge's mind, handle lawyers, manage clerks and clients. If you are a first-generation lawyer, these difficulties increase manifold. From my experience, I can say obtaining law degree is easy. However, it is extremely challenging to earn livelihood and face the challenges, and surviving in the profession is very big issue. So, we have to keep these things in mind. Why are you studying law? Sometimes these are the questions we faced during our times, not now. Because according to the people at that time, law is the last resort and last course which people used to take. First question they used to ask is, why are you studying law? Did you not get any employment? Or you not getting any marriage proposals? This is how they used to question when we joined in the law those days. Of course, those days has gone. All jovial laughs aside, as young aspiring lawyers, apart from knowing law, you must understand the legal system and its interdependence with the other institutions. Let us begin by understanding India's progress and paradox. India's growth story is filled with resilience and revival. We have sent successful missions to space. We are leaders in digital transformation. Our economic growth is admired across the world. Yet, alongside this remarkable progress, we still have persistent challenges of poverty, malnutrition, unemployment, etc. While the journey so far is laudable, there are many who is still waiting to receive their benefit of growth. The above picture of India often reminds me about the words of Charles Dickens, who has explained in his novel, Tale of Two Cities. He portrays despair and hope. This is the duality of India. Growth without equality is incomplete, and development without justice is fragile. In this background, as the members of legal fraternity or law students, where do we stand? What role can the legal system play in bridging this gap between aspiration and reality? The answer lies in reaffirming the true purpose of law. Why do we need law? We need law because it regulates human behavior. It is an instrument of social change. Where there is law, there is order. Where there is no law, there is anarchy. As Aristotle once said, man, when perfected, is the best of animals. But when separated from law and justice, he is the worst of all. Unquote. Statutes or laws will remain as mere words on paper unless there exists a system to give them life. The Indian legal system began as a colonial inheritance. However, post-independence, Indian courts have emerged as central pillars of constitutional governance. Now, what are the challenges before the courts? Now, I will tell a small saying in all languages, almost Indian languages, a popular saying. It says that while a litigant who loses the case cries in the court, the winner cries after going back to his home. So, it may be humorous, but these words reflects a painful truth which points out towards a deeper crisis, that is people's faith in the institution. The strength of the judiciary lies in the trust of people. Without the trust, even the most reasoned judgments become meaningless. There are several factors which are leading to the erosion of the public trust. These are pendency of cases, high costs of litigation, procedural complexities. All these ultimately affect justice delivery. When people lose trust in courts, they start looking elsewhere. Justice for justice. This lends to unrest, violence, and breakdown. The trust is one of the most important component where we have to depose and try to protect the image of the institution. It is not new to the judicial institutions to face the issues of credibility from time to time. Of late, the criticism has been severe, perhaps one of the strongest challenges. This is where the judicial leadership will rise to the occasion. Now, the next question is, who has to render justice? Delivering justice is not the burden of one institution. It is the responsibility of all constitutional stakeholders. Even our Constitution under Article 38, 39A places an obligation on the state to render justice. The blame of delay cannot be attributed to judges and lawyers alone. In this light, let us see how the other constitutional bodies have to perform their duty to ensure the functioning of the legal system. Many people think that laws are made by the courts. We have to dispel this notion. The legislature who makes laws. Unfortunately, rushed legislation without adequate foresight clogs the judicial system. Poorly drafted laws inevitably multiply litigation. Refinement of proposed laws requires consultation with all stakeholders and meaningful parliamentary debate. Unfortunately, this exercise has declined in recent years. We need to assess the ground reality and practical impact of constitutional amendments and legislative enactments. Now, after decades of their implementation, we need scholars and experts to analyze which of those amendments have truly brought positive changes in the lives of the citizens. I hope this university takes up some projects on this subject. We need to ascertain whether the changes were merely cosmetic or have they served their purpose, or do they need further changes. It is the duty of the government to strengthen the judicial infrastructure and create courts to meet the growth and needs of the people. I want to bring all of your notice. As the Chief Justice, I tried my level best to create an infrastructure corporation across country to take care of the infrastructure of the judiciary. Unfortunately, government has not cooperated. That's a different story. Now I want to show you a public notice issued by this National Company Law Tribunal in Delhi. It is in the capital city of Delhi. We all think that now this most important judicial, more than Supreme Court, High Court, it is the company law tribunals which are attracting the public and which are discussed too much. They issued a notice on 3rd September saying that we are closing the courtrooms because we don't have infrastructure. The building is leaking and may cause serious deterioration of the false ceiling, creation of imminent risk of collapse, short-circuiting of electrical fitting, and consequent fire hazard. The situation poses a grave risk of the safety of the honorable members, officers, registry, land advocates, litigants, all other persons. This is the stage of the tribunal, National Company Tribunal in Delhi itself. Imagine the stage of the construction or the infrastructure across the country about the other courts. So that is the reason why we, as members of the legal professions, particularly lawyers, must take up these issues. Judicial efficiency greatly depends upon the timely filing of the judicial vacancies, appointment of the public prosecutors, etc. We live in today an age of over-governance. Excessive and poorly designed rules create more disputes. The overload caused by a regulatory culture adds to burden of pendency. It is expected that the executive follows the principles of natural justice before taking any action. Otherwise, people has no option except going to the courts. Moreover, the authority of the courts depends upon the implementation of their orders and judgments. But unfortunately, majority of the judgment, until unless you file a contempt, they are not going to implement. Now coming back to the criminal justice delivery system, the administration of criminal justice is a big punishment because the process has become a big punishment. By the end of the day, you may get acquittal, but many days you have to be in jail without getting a bail. So this has become a big punishment. Fundamental reforms must begin with public prosecutors. They must act independently. They must be answerable to the courts, not to the bosses who they appointed. The investigating agencies must equip with latest technology and must be answerable to the courts. Police must be accountable, and faulty and delayed investigations lead to wrongful confinement, incarcerations of innocent citizens. These things has to be corrected. Now, what can lawyers do to address these issues? During the freedom struggle, we have seen Mahatma Gandhi, Jawaharlal Nehru, Dr. Ambedkar, Tanguturi Prakasam, Rajagopalachari, Sardar Patel, who mobilized the entire nation and people against the British, against the colonial injustice. They were lawyers. Many sacrificed their liberty and properties to pursue this independence movement. Post-independence, lawyers played an equally crucial role in drafting the Constitution and shaping legislative bodies. Their legacy highlights the noble responsibilities of the legal profession. But presently, we are witnessing the declining trend of lawyers in public life. Today, how many lawyers are taking up the role of legislators? An electoral contests grow, resource intensive. Fewer lawyers entered legislative life. The legal profession itself become more specialized, commercialized, and inward-looking. Lawyers have been accused of profiting out of misfortunes. In a lighter way, in an English saying captured this, I quote, "For fees to any form, they mold a cause. The worst has merits and the best has flaws. 5 pennies make a criminal today, 10 pennies tomorrow wipe the stain away," unquote. A lawyer's duty extends beyond academic interests. The integrity of advocacy is as important as the wisdom of the bench. The independence of the profession must be safeguarded against intimidation and interference. The collective voice of Lawyers Association should champion the rule of law. And very recently, we all witnessed such exemplary actions. Another issue which now we are facing about the gender diversity and inclusivity. The issue of diversity and inclusivity on the bench is a very serious problem. In 75 years of the Supreme Court, only 11 women have been elevated so far. The last time women judges were appointed to the Supreme Court was in August 2021, when 3 distinguished women joined together. Now there is only 1 lady judge in the Supreme Court. Our institutions must reflect our social fabric. Gender diversity and inclusivity is not tokenism. It is the necessity to enrich our perspectives with social realities. This issue needs larger consideration. Inclusivity does not happen naturally. Judiciary also not immune to this. Bringing inclusivity calls for concerted efforts at the highest level. Now, and what is the message I want to tell to the young students is, legal education does not end in classrooms. There is a great disconnect with the grassroots realities of our society. Books will teach you the letter of the law, but society will teach you its spirit. As young lawyers, you must expose yourself to varying experiences of legal practice in trial courts, tribunals, different institutions and forums. There are another dimension we often overlook: the cultivation of scientific temperament and critical thinking in society. The spirit of inquiry must guide every stage of you. This is the essence of advocacy. Being equipped with the knowledge, we have the responsibility of promoting constitutional culture and simplifying its principles for the public. Sadly, even today, many citizens do not know their constitutional rights. In fact, even lawmakers and lawyers sometimes fail to grasp its spirit. We have a great constitution. However, the constitutional scheme is not effectively working. We must work towards the proper implementation and realize its goals and aspirations. It should be our constant endeavor to bridge the gap between the Constitution and the people. As future national builders, carry forward the spirit of the Constitution in every step in your career. Be fearless and upright. I will end my speech with Rabindranath Tagore, where the mind is without fear and the head is held high, where knowledge is free into the heaven of freedom. My Father, let my country awake. Thank you very much for giving this opportunity. Thank you.